sentencing. It cannot, sentencing cannot be done today, 319 cannot be passed tomorrow is your contention.
Please.
But according to the Solicitor General, it can be done even tomorrow.
That's my submission.
He can refer to para 42 also if he wants quotes from that. Para 42.
Then tomorrow, then after a week, after a month, after a year.
When they have a look, Manoj, then the test of proximity, whether it is mala fide, whether it is the test of proximity, etc., may be applied. But there is no prohibition. My contention is 319 does not prohibit the passing of an order after the trial, Manoj, is over. The language of 319 is not such that the order cannot be passed after the trial is over. The language is clear. The language only says the evidence collected during the trial. Nowhere in section 319 is a reference, even directly or indirectly, which suggests that an order under 319 cannot be passed after the trial is over. I'll illustrate, Manoj. I'll illustrate by an example what will happen, Manoj.
So you want us to ignore the
I'm saying
you want to
argue for 5 minutes.
What is that you want? I will
Only for on the points of assistance, Your Lordship, with regard to the concept of whether the just mere fact that the judgment has been pronounced.
who are you?
Because I filed an implement.
Why do you want to assist us with so much of assistance?
Because I was only
File an implement, but on whose behalf?
because on behalf of the Delhi Prosecutors Association, Your Lordship, I have this association. Your Lordship,
What is your role in this case? What is your role?
Lordship, only as assistance, not on the facts of the case.
Tell us all right.
Points, because everything has been summarized.
All right, tell us.
Your Lordship, mere fact that the pronouncement of judgment has been done.
What does this matter to do with the welfare of the Delhi prosecutors?
Was only to assist Your Lordship, only to make some legal submission, only 2 submissions. Most of the submissions have been incorporated.
What if they can file applications after judgment?
Oh, no, Your Lordship.
See, you are also bound by 319, no?
Yes, Your Lordship, this is what I am submitting.
No, here you can, how can you file an application in 319?
In fact,
If you have done your job properly, this reference would not have come.
Please, Your Lordship, that's why I mean,
Prosecutors.
there is a difficulty with regard to that part. It's only 2 submissions, if I may.
All right,
Your Lordship's
please,
permission.
please.
The only consideration which this honorable court has to make, whether mere pronouncement of judgment makes a judge functus officio. It has already been argued that till the time sentence is imposed in a judgment of conviction, the judge has the jurisdiction. Section 235 says.
Don't repeat. This is argued. Something new. This is argued extensively.
There's one more. Only section 236. 2 provisions which will show that even after pronouncement of judgment, the judge is required to act under the statute. 236 says that in case there is a previous conviction charged, there are offences when there is a subsequent conviction. In that case, the judge, even after the pronouncement of judgment, is required to take evidence. Even after pronouncement of judgment of conviction, is required to take evidence. Your Lordship, may kindly have
evidence for what?
For alleged previous conviction. Lordship, may kindly have section 236. This would show that
for the purpose of sentencing.
Yes, Your Lordship.
That is well taken.
No, not sentencing under 235. Under the enhanced sentencing because there is an accused who was previously convicted for some other offence. If a previous conviction of that offence is going to be aggravated,
provision, which
236, Your Lordship.
236.
Yes. Yes. Taking the punch. Lordship, may kindly have 236.
That should be one of the considerations.
Yes.
For conviction. Well taken, sir. Well taken.
In the present
Everything will be heard. All these questions will be heard after conviction is judgment is in which provision?
235.
For sentencing in the present case about the other cases. So sentencing includes that one.
Ms. May I just,
That is concurrent.
Ms. 236 says,
current or something.
yes, I am relying on that the word is to take evidence. So that if a judge is declared functus, if you say that trial concludes when only a judgment of
Don't repeat the arguments. The Advocate General as well as Mr. Prasad have already said that the judgment doesn't complete with the order of conviction.
order
It continues till
Your Lordship.
the sentence is finally imposed.
Only for the purpose of.
And similarly, in section 248, the same is repeated.
All
And Lordship, one last submission is with regard to, there is an issue, what is the right stage when the application under section 3119 should be made by the prosecution, because all this entire issue has arisen because there was a delay in making the application, there was a delay in disposing the application.
There was no delay in making the application. The delay was in deciding the
Lordship,
application.
under section 276, even under delay was also there when the witnesses were examined. Because under section 276 of the CRPC, the judge has to take the evidence under his dictation and it is signed, and the prosecutor is present. So, if that would be the right stage for a judge to take cognizance under section 319, or for the prosecution to file an application under 319. They should not wait till the final conclusion that, okay, now every witnesses have been examined.
On question number 3. Guidance.
Look, these are my
We have sufficient guidance from you now.
well, we are
All right,
here
all
to
right,
learn.
sir. All right. Yes, sir, Mr. Patel.
Make these.
Pronounced anything cannot. We'll come at 2, sir. We'll come at. All. Go just.
Yes,
Supreme Court judge cannot be thrown out there.
yes,
If they want to,
Yes.
even if they want to.
yes,
It's an elaborate procedure.
correct.
So that is something which is may not have anything to do with his, his competence.
Yes.
You may have a competence, you may have a need.
No,
As
yes,
Dr. Ambedkar says.
absolutely.
So that is the area, where we are a little, we.
No, so which is why, my lords, every time, I mean, your lordships are better placed than I am. Every time your lordships have been on interview committees to appoint judges, for example, your lordships will have the basic parameter of eligibility, which are the basic qualifications, etc. But above that, there will be discretion which you will have, whether you put it down as a procedure which you must look at, or whether you don't. There is always, and there has to be, discretion available with that committee or that appointing body to say, let us look at quality of his judgments. Let us look at his deport. Does he lose his temper in court when you are appointing a judge, for example? So similarly with this, surely there would be a methodology which would be available for you if you know that, look, lots of decision making which has not been independent in whatever post he held. As a secretary, he was supposed to take action, he took action against only people.
The second follow-up question also is
Yes.
relevant.
Yes.
You see, it is perhaps, we have to be sort of a little personal.
Yes.
It's part of history.
Yes.
The Election Commission of India perhaps is the envy of the world. This is one institution which has come in for a lot of compliments.
Of course. It's a massive act.
Particularly after a particular individual took over.
Yes.
We all know
Yes.
that. It's
Yes.
the TN station.
Yes.
Calling sort of very despotic, as some people. Back to the matter is that he mustn't his way through.
Yes. Left his mark.
The question is this, something slightly different. What perhaps Asian succeeded in doing was putting in place a lot of mechanisms in the form of rules, how the commission, because it's an election commission,
Yeah.
maybe the chair of the election commission alone or with the assistance of the, as held in Sessions case.
Yes.
Whether it is more important that that the discretion of the election commission, as my brother put to the question, is reduced to the minimum, because discretion power is inevitable.
Yes.
You will have power.
Correct.
So how you respond to a particular situation, political party comes,
Correct.
do this.
Yes.
You have a set of rules which, if they are followed,
Yes.
you will eliminate this, this fear that you will be dependent on the powers that we will act in,
Of course.
sort of foster their interests.
Yes.
So is that as important as also the persona, the person's attitude, his independence, his character, competence?
I think for way too long, and this is again, since your lordship mentioned this, I think for way too long there have been positions which at the beginning, at the time of independence, I think people who populated those constitutional positions were well aware of the strength and the level of independence available in those constitutional positions. Unfortunately, in days that have come, we have seen those positions not being not enhanced, but being exercised in the manner in which it can be to its fullest. Any of these gaps that your lordships have been filling up, particularly in electoral reforms, your lordships have seen so many cases in which you've filled up gaps. Those gaps didn't need to be filled up by this court. With the greatest of respect, the Election Commission had the power, just like they passed the symbols order. They could have passed a series of orders which 324 permits them to do. Superintendence, direction, control. 3 words which vest in them the widest of powers to ensure that these loopholes are fixed, but they didn't do it. Either they don't recognize the extent of their power. I think after your lordships have repeatedly said this over 30 years, from Sadiq Ali onwards, I don't think there was a doubt. Even in 52 in Ponuswamy, your lordship, 6 judges made it clear about how this part is almost like a complete code, the wide powers that are available. Now, considering that, we have seen that the individuals who have populated these posts have not exercised the powers which are available. If they have not exercised it, and it's fairly manifestly evident that those powers are there for them to exercise it, there must be something that we can't see. Occasionally we get glimpses of. Occasionally, like the election commissioner Naveen Chawla's letter, which I enclose in the counter affidavit, he mentions that, look, Mr. Session did not get along with Mr. Gill and Mr. Krishnamurti, so he tried to stymie that, and fortunately the court has held in our favor. He says there was a recommendation now to remove me by the CEC, and the court has, the government has rejected it. So thankfully I'm here. Here are some reforms I suggest. So they're always having this pressure, this knife hanging over their heads. So it's very difficult for us to estimate the extent of that. We are standing on this side. I have no clue. We cannot try and inform your lordships, or apart from what has come out. And there are many instances. I'll give your lordship one more example.
Come out with any mechanism as on today. Will they follow in making appointments?
Not that the government would have to tell your lordships. Not that we know.
Your petition you must have questioned, and their response is
We
there.
have said that there
They
is
have
no.
filed the response also.
Yes,
they have filed the
they
response.
filed a counter.
So what we are requesting you is, have they come out
It's
with the mechanism they have adopted in making appointments?
in my petition, the appointment process was not in my prayers, as your lordship have seen. My last prayer is a wider one. I'm presuming it must be in one of the other petitions what their response is. But since we don't have a law, we don't have rules, it's definitely not in the constitution. We don't know what the process is. The appointment eventually is by the president. As judges appointment by the president eventually. It's his warrant. But the process that is followed.
You want to know the process. Appointment maybe by the president.
Correct. So
But we are concerned with the process.
yes, but what we are presuming, and the basis on which we are proceeding, is that it is following Shamsher Singh, Westminster form, the government, the cabinet recommends a name and the president goes ahead and puts his. If it's a president acting on his own, I gravely doubt it.
Rules of business.
Yes,
Under the rules of business under 77,
yes.
probably they might have some.
They may
might
perhaps have that. I'm
Ultimately,
sorry.
ultimately, it's a council of ministers.
Yes, ultimately it's the Council of Ministers, my understanding. If it's something else, I could be
Executive,
corrected.
purely executive.
Yes.
Nothing much about it.
One other thing I wanted to touch upon is that very often we have seen that election commissioners or the election commission, if there is governmental influence on the election commission, a decision which should be taken immediately, should this symbol go to that party or this party, will take months. Something we have found with speakers of the various houses as well.
And political bias.
But yes, that political
That is
bias.
Political bias independence.
Correct, but the political.
What you're saying is, how
Yes.
do you actually get somebody
Yes.
who will be above politics?
So-
who's not partisan.
Correct. So
This
we.
even if you get the best of people,
Correct.
most neutral a person.
No, I agree. So what?
Who do you
What?
select? Because the process is the ACR.
Yes. So, in my view, you have to start at the top, give them independence when they are appointed, give them protection during their tenure, make them recognize the extent of their powers, and ensure that any assault on any one of these three is strictly checked. We are at stage one, at the process of appointment. It's still not something that will be a complete.
We're concerned with that.
Yes.
We're concerned with that.
That protection is there. Written
Only for
five provides.
only for the CC, but not the election commissioners is what has been.
That's right.